My name is Stephen Leskin. I am a divorce mediator and attorney in Portland, Oregon. Welcome to this bi-monthly webinar that I put on to cover divorce topics. Twice a month, I pick a topic, a divorce topic, and spend an hour or so talking about it. I cover such issues as child support, child custody, parenting time, division of property, division of debt. I go through what a divorce trial looks like. So I give people a pretty good idea of what to expect if you're going through a divorce. I do this because I think that the more information people have, the better decision makers they can be, and I want to support them in that process to get the best outcome for them and also for their kids and for their ex-spouse. I genuinely believe that the more knowledge you have, the better decision maker you will be, and that's why I put these seminars on. You can find a library of my seminars, and you can sign up at my website, leskinlaw.com. You can also find me by searching Google for Oregon Divorce Mediation Services, and that will get you to my website, or Stephen Leskin will get you there also. Either of those will work. A little about me. I was admitted to the practice of law in 1992 in Oregon. I practiced in the Portland area. Except for a brief time, I've been a solo attorney all of these years. I'm on the Alternative Dispute Resolution Committee of the Oregon State Bar and also a board member of the Oregon Mediation Association. I regularly speak on topics related to divorce mediation. You can visit my website for a library of videos of my talks and these webinars. I think at this point there's 50, 60, or maybe even a little bit more of the webinars that I've hosted. So my webinars are usually not about self-promotion in the least. I spend an hour picking a topic and doing a really deep dive on that topic. And I take a lot of pride in that service, that I'm offering the community objective information. However, tonight's webinar is 100% self-promotion. And I'm not making any bones about that. And that's because I'm particularly proud of my process, the one-day divorce mediation process. And tonight we're doing a deep dive on one-day divorce. We're going to talk about what it is, how it works, why it works, where it's appropriate, where it's not appropriate. I'll discuss fees and scheduling. And by the end, you'll have a really good idea of whether or not this process is right for you and your spouse. So let's get into it. The background of one-day divorce is a couple of years ago, I'd taken a short break from the practice of law. And when I came back, I wasn't quite sure what area of law I wanted to practice, but I knew that if I came back and was going to do family law again, that I could not continue to do divorce the way that it's been done for all of these years. Litigation is expensive, it's time consuming, it's stressful, it does not always get to the right outcome. And I was tired of seeing my clients spend tens of thousands of dollars when they didn't need to. As a divorce attorney, I'm going to tell you that there are things I need to do that cost my clients money that are required but don't necessarily advance their case. And that happens fairly regularly. And I don't think that offered good value for my clients. I've been to court so many times over the years where I've not gotten what I thought was the right result. Certainly you lose cases, but there have been too many times when I did not get the result that I think that the facts and the law warranted. And I was tired of that. And I think, most attorneys will tell you that as well. So I set about like figuring out how I could do divorce better. I spent a lot of time thinking about it. I eventually came up with a hybrid process. So let me tell you what that process is, and then we'll break it down and get into how I apply that. So mediation is the process of working with a neutral third party, independent person, professional who's going to go back and forth between parties, whether it's divorce or commercial dispute or anything, and help the parties come to their own win-win solution. It's about creating opportunities for people to say, yeah, that works for me. Like that's my goal, is to get to that. Yeah, I can do that with two people. And Um, that's the mediation process. You go back and forth, you go back and forth, you go back and forth until um, you work out something that works for the both of you. And when that happens, the parties own the result. It's their result. Um, as opposed to going to court, where if you can't get an agreement, you go to before the judge, and the judge says, "Okay, this is the way it's going to be," and that's litigation. So I wanted to design a process that involved um, mediation because I believe in the mediation process. And I found that as a mediator, I'm pretty good at it. I have a skill set that works really well in a mediation setting. But I wanted to design a process where couples would know that they had finality and that they could do it on a budget and that they weren't entering into an open-ended commitment at a couple $100 an hour with an attorney, and where they would know that the process would be done on schedule. Traditional mediation is just we're just going to talk until we get this done, and that could last weeks, that could last months, and I didn't want that. I wanted a process that was had a definite beginning and a definite end. And so I didn't create it. There is a hybrid mediation binding arbitration model out there, but I adapted that model uh, to the divorce process. Binding arbitration is where the parties agree to meet to the arbitrator, and the arbitrator makes the final decisions. It's similar to a court case, except the rules of evidence are going to be relaxed. The arbitrator will get to know the parties better. Uh, and so I combined mediation with binding arbitration so that people will know that their divorce will be done in one day. And the way I do it is we start in the morning, we mediate all day, and by the end of the day, if the spouses have not come to an agreement, then I step into the role of arbitrator and make the final decisions for them. In the 3 or so years that I've been acting as a mediator in uh, my 1 day divorce process, that's actually only happened once, where I had to sit down and make the final decisions for people on a substantive issue in the divorce. A couple of times it's happened where like the couple is just at the end of the rope and they can't decide on like a couple of small issues and they say, we're done here, you decide. I don't really consider that, you know, substantive, but that's just like, we just have some loose ends. We just can't quite get there, so you decide. But it's only happened once where like there was substantive issues like the sale of the house. I think the big one was the sale of the house and how the equity was going to get divided. It's only happened once because my mediation process is so strong that people will generally get a resolution even before they get to the mediation. So what we do is my process is um, it's a mediation. We start doing mediation, and by the end of the day, if we can't agree, then I step into the role of arbitrator and make the decisions. Am I qualified to be an arbitrator? Yes, I was a municipal judge for years and years and years in Washington County. I have that background in training. I've been a divorce attorney, as I've said, for 30 years, for a really long time. So I know the law. I have a pretty good sense of what courts are going to do just because I've been around them for so long. And I bring that experience to the mediation. So that's how I came up with the 1 day divorce process, is that I put those things together. And I realized that once you, as a business person, once I know how much time um, the process is going to take, then I could set a set fee. And so I do my um, process, my mediation arbitrations in 1 day, and I know how long it's going to take to do the court documents. And so with that insight, I can set these on a set fee. So when somebody comes to me and they say, we want to do it, how much does it cost? We do a couple of calculations, and I said, this is what it's going to cost. And I have never varied the price. It's the price I quote you is the price that you're going to pay at the end. So it's done on a schedule. We know what day we're going to do the mediation, and clients and spouses know um, when it's going to be done and how much it's going to cost. So that's an overview of my 1 day divorce mediation. I also had another insight that there are a lot of couples out there who they're at the end of the marriage, they're still talking, they just kind of realize that the relationship didn't work out and they need to move on, but they can't quite get it done themselves. there are a lot of couples out there like that who like fit that model where um, we know, like maybe we have kids and we know we have to preserve the relationship because we're both going to be parents for the next well, for forever, but with minor children for years more, and we have to preserve the relationship. These are couples who would be ideal for going through the one-day divorce mediation process. Uh, the process will not work where there's um, distrust. So, for example, if you don't trust your spouse to disclose all of the assets or the liabilities, you need to be in court. Only through a court process can you compel your spouse to produce documents that you need, excuse me, that you need to make your decisions on. As a mediator, I don't have any judicial authority behind me to compel the production of documents. I have that as an attorney, right? I can get that through legal mechanisms, but I can't as a mediator. So the first question is, do I trust my spouse to negotiate in good faith and produce all documents that we need to get a resolution? In my process, there may be differences of values. For example, someone may say, "Oh, I thought," excuse me, my nose is itchy, which is a rarity, but it happens when I start talking often. Um, a couple will say, "Well, I thought we had $10,000 in that account." And the other will say, "No, it's only 2,000." There's an easy way to reconcile that, right? You just produce a copy of a bank statement, right? So we can just deal with where there are differences. If there's differences, for example, in the perception of what equity is in the house, like for example, I think the house will sell for $500,000, but my spouse thinks it will sell for 800,000. That's easy enough to resolve. You just get an appraisal of the house, right? So there's ways to deal with differences like that. But if one of the spouses won't pony up a bank account, so we can't verify it, then there's problems. So you have to have a fundamentally a view fundamentally that your spouse is a trustworthy person to negotiate. My one-day divorce mediation process would not be appropriate where there are um, complicated financial instruments that I don't have the financial background to deal with that. Or like, for example, like stock options or, certain employee benefit plans are very, very complicated to deal with. So those are something that's subject to a discussion with me to figure out whether or not that's a right fit. Also, if there's complicated financial or medical planning, uh, that's better. That's a better process that's done through the courts or with two attorneys as opposed to one. So those are some of the things that would disqualify people from going through a mediation process, and particularly my mediation process. So it works for people who are working together. They want to preserve the relationship. They're still, they're friends. Maybe they're not as close. They're not as intimate, but there's still that bond there. Uh, my process works really well in those circumstances. So what is the process? Uh, I'm going to talk about onboarding in just a little bit, but I want to get right to what what the 7-step process is for one-day divorce mediation. After onboarding, um, the first step is gathering information, and I do this through online questionnaires that I developed myself over very, very many years, and they're designed to get at all of the bank accounts, all of the vehicles, all of the credit cards, all of the information that is needed to divide up real estate. And the online questionnaires are pretty straightforward. And if you have a pretty simple estate, it won't take more than a half hour to fill everything out. It take longer if they're kids because kids require a lot more information. But generally, both parties fill in their questionnaires, and then the next step is we exchange that information. So uh, information comes into the office, and then it goes out in the form of a letter, in the form of an inventory, and um, both parties see what the other party filled in, and then we meet at a third step at a pre-mediation conference. And at the pre-mediation conference, we go through and we say, okay, are we in agreement? Are we not in agreement? And what do we need to verify values if we need to, or where do we need to, where do we think there's difference of opinion that we need to resolve? And we go through all of that. The other thing that I do that is unique, and I think is part of the reason my process is so successful for people, is that I explain Oregon law, and I explain Oregon law in a neutral way, not meant to benefit either party. And I found that once people know what the law is, they have some security in their decision making, right? And both parties hear it at the same time, so they come away with the same knowledge, and they can say, "Oh, all right, well that makes sense. This is what I'm going to do," or "No, I'm not going to do that. I'm not going to give that up. Oregon law would not require me to give that up." So both people having the same knowledge base about Oregon law, I think really, really helps people frame their decision making and inform their decision making. And I think that once people have, it's no longer an I think, I've seen it enough, that once people have an explanation, um, an objective explanation of Oregon law, it just eases their decision making. Both parties are on the same page, and it just makes the decision making easier. The other part of knowing Oregon law, and I explain this to people, is that if one or both of the spouses can't agree, well, both of the spouses, that's nonsensical. If they can't agree, then and it turns into a mediation. If it turns into an arbitration, they will know what my perception of the law is and what the likelihood of their success will be if I have to make the decisions. So, for example, if I explain under certain circumstances, a party gets their down payment back on a house, and they can't agree on that, and then they know it's going to come to me, and I say, well, I told you that the husband's going to get his down payment back. That's what I'm going to do as the arbitrator. So there's not going to be any surprises, right? So everybody's on the same page, and I found that process works really, really well. I can explain Oregon law because I've been doing this for so long. There's very little that is going to throw me. If in preparing for the pre-mediation conference, I come up with something that I don't know, I'll look it up and I will know the answer going into it. Occasionally, clients will ask me more in-depth questions, and I'll get back to them. And if I don't know the answer, I'll say, I'll get back to you. And I send a joint email to both of them so that everybody's on the same page. And that point gets me to something that I need to explain, is that if somebody hires me as a lawyer, everything between them and me is confidential, right? They have a privilege to tell me things that cannot be disclosed to the court almost under any circumstance, right? There are circumstances where it can be compelled, but as a general matter, anything said in the course of divorce is confidential. And the explanations for law, they come from the attorney, and the attorney, is trying to get a favorable outcome, so they explain it favorably. So my process is transparent in the sense that somebody asks me a question, I'm going to send an email back with the answer to both of them. So my model is not built on opaque and privilege; it's built on transparency through the whole process, and that just makes the process work better because it just sends the message that we're all on the same page, nothing's being hidden. And that as the arbitrator, or the mediator, I'm trying to get work between the two of you as a neutral and independent. So transparency in this process is very, very important. So the three things that we always go over at the pre-mediation conference are the facts. We make sure that we have all of the facts established by the time we're done with the pre-mediation conference. We discuss Oregon law. And the third thing is I give an overview of what the mediation will consist of, and go through what the ground rules are and how it's going to work and how we do it, and make sure that everybody's comfortable with Zoom. And then the mediation will take place 2 weeks after the pre-mediation conference. And I do that for a very specific reason. If there's information that's necessary for the mediation, that 2-week period is more than enough time to gather any outstanding information. And it gives parties, the spouses, a chance to think through their positions, and maybe discuss it between themselves now that the facts and the law are worked out, and we're all on the same page. And then we do the mediation, and my mediations usually start at 9, and I block out an entire day, unless it's a really simple mediation. I usually block out an entire day, and I'll start with. I usually start with the wife, just to make it easier for me to remember. And I'll sit down with the wife, and we'll talk in general, and we'll talk about specifics and her concerns. Then I'll talk to the husband and talk about generals and his specific concerns. And then we'll start picking a area to negotiate in, and we'll go through, go back and forth, back and forth, and back and forth until we have everything resolved. And then, as I talked about earlier, if there are still things that the spouses can't resolve by the end of the mediation, I'll make the decision for them. And then at the end of the day, everything's resolved. And then I do the paperwork for the court. I put together the judgment and all the other ancillary documents that need to be filed, and the parties review them, and then they sign them, and then I file them, and I pay the filing fee, and then the court will sign the divorce. Presumably, the court will sign the divorce judgment without kicking it back for more development. So that's my process. My start to finish time now, I keep metrics on this. My start to finish time from the time people sign the representation agreement to the time I get the documents to the court is 48 days. A simple divorce, I'll cut that down to 2 weeks, to a 2-week prep period, and shave off 2 weeks. But generally, we're talking 48 days, 6 weeks for parties to get through my entire process. And the reason I know that will work is because during the onboard processing, I'll talk about onboard processing now. Part of my onboard processing is having people commit to the pre-mediation date and the mediation date. And so by the time the onboard process consists of signing the participation agreement and paying the legal fees, the mediation fees, and picking the pre-mediation conference date and the mediation. And once those things are picked, that's the date they're going to happen. And the mediation date rarely changes, but so that's the date that people know that they're done. And then the other two things to talk about are fees and scheduling. I set flat fees for people, and that the flat fee is based on the complexity of the case. So how much assets spouses may own, whether or not there's kids, whether there's self-employment, what types of retirement accounts they have, whether or not it's a 401k or a pension. And so you can find my prices on my fees, I should say, on my website, leskinlaw.com. And you can calculate, usually by the time people are done talking to me, the fees will be a little bit lower than what they found on the website. But you'll have a pretty good idea of where the fees will come in. I just the other day I was talking to somebody who was with a mediator and they weren't happy with it. And I looked at the mediator's website, and their flat fee was $11,000 to mediate. The fee for that person was going to be $4,000. So my fees are often less than other mediations. There are all kinds of models for mediation fees. Some people do it at an hourly rate. Some people do it on a flat fee. You have to be careful what you're paying for. Some attorneys will do the mediation for a flat fee and then charge hourly to do all the paperwork, and that could add several $1,000s to the cost. There's also a filing fee, $301. I include that and then pay it. I include that as part of my fee and then just pay it directly, so there's no other costs. In my model, if there's a 401k or a pension that needs to be divided, I have another attorney do that. That's an area of expertise that is not my area of expertise, and so I hire another lawyer to help me with that. And usually that fee is $1,200 to $1,500, and the parties pay that directly. So that's my one-day divorce mediation process. It works. My process works really, really well. I'm really proud. Really proud of how well it works for people. And if you're thinking about it, I encourage you to give me a call. You can find me online at leskinlaw.com. It's LESKINLAW.com, or you can search Stephen Leskin, or Oregon Divorce Mediation Services.com will also get you there. I hope you found this informative. Please see my website for a library of other divorce mediation and divorce topics. And I hope that you find something there that helps you and helps you get through the process a little bit easier. Thanks for watching tonight. I appreciate you being here.